Okay, well, because it's 3 o'clock, we'll get started while some people are still coming in. Hi, everyone, and happy December and holidays. My name's Bree. I'm the lead public health trainer for the Franklin Hampshire Field Training Hub, which is hosted out of the FRCOG. We hold these power hour trainings in conjunction with Western Mass Public Health Association, and we are recording it. All of the slides, the recording, and some sample documents will be sent out after the fact. And most of them are already available on our website. Liz, if you don't mind putting our website into the chat, you'll be able to access most of it besides the recording after today. So I don't think I missed anything. I'm just going to share my screen. All right.
It's Freeman, F-R-E-E-M-A-N. What's your place now? Okay.
I think if you're not muted, if you don't mind just muting, because someone's got some background noise. Okay. So Liz, can you see the screen all right? The presentation? Okay, perfect. All right, so today I wanted to go over tanning just because I feel like it's one of those random regulations that we're responsible for we've never really been formally trained on. I don't know about you, but I've never gotten any formal training on tanning. So I am not in any way, shape, or form an expert on this, but I have worked in communities that have had tanning, and the regulation is fairly short. So we're basically just going to go through the ins and outs of the regulation. And then I'll also provide some sample forms, which I think are really the most helpful part of this presentation. I have an inspection form, an application, a warning sign, and an injury form that you can use if you'd like in your community. Okay, so as always, this training is sponsored by Western Mass Public Health and the Franklin Hampshire Field Training Hub. It is not an official training of DPH, the Office of Local and Regional Health, or our statewide training hub program. So why do we regulate? Indoor tanning is a known carcinogen. Indoor tanning can increase users' risk of developing squamous cell carcinoma by 58% and basal cell carcinoma by 24%. These last two bullet points remind me a lot of tobacco. So using tanning beds before the age of 20 can increase your chances of developing melanoma by 47% and increases with each use. And adolescents who engage in indoor tanning before the age of 18 are more likely to continue indoor tanning as adults. So I thought that last one was interesting because it's kind of the same when we increase the age of tobacco to 21. There's such a small percentage of people that start smoking after the age of 21. Most people start, when they're in their teenage years. So I thought that this was an interesting statistic. So the tanning regulations are 105 CMR 123. And in May of 2016, the Mass General Law changed to prohibit anyone under the age of 18 from using or operating a tanning device. So then DPH amended their tanning regulations in February of 2017. And if you're working at that time, you're right, you might remember when DPH sent out a memo regarding the changes. So that link right there is live. So when we send out the slides, you can check out what the changes were in 2017. So obviously, the operator shall ensure no customer younger than 18 years old uses a tanning device. And that also goes for employees. They can't be under 18 years old. So if you do an inspection and you think that the person at the front desk seems pretty young, you can ask for a copy of, their employees and what their ages are. So I'm not going to go through all of this, but just know that the employees have to be properly trained and knowledgeable. So just like the food code, whoever's working has to have the minimum knowledge of the tanning code 105 CMR 123. Skin type determination and proper use of the manufacturer's recommended exposure schedule, which we'll go over in a few slides. Photosensitizing agents such as foods, cosmetics, medications, recognition of an injury from being overexposed, effects of ultraviolet radiation, etc. And the use of protective eyewear is an important one. So they must have a list of all trained employees and be available upon request. So when you do your inspection, they should have a printout or somewhere written all of their employee names and ages if possible, if you think that they're under 18. So the operator shall determine the duration of the tanning session for each customer based on their skin type. I find that this doesn't happen. I find it during inspections, and I also just find it personally. I go tanning before I go on vacation if I haven't seen the sun in 6 months, so I don't get burned. And 9 times out of 10, they don't tell me how long. They always ask me, how long do you want to go in for? They're technically supposed to be telling me how long I can go in for based off of my skin type. And the operator shall provide a copy of the tanning device manual or the name and address of the manufacturer upon request. So we'll get into this later. I think it's under records, but they do need to have copies of all the manuals of all of their tanning devices. So this is the FDA skin type scale. I believe that this is the skin type scale that they're referring to. I don't believe the code gets into the skin type scale, but the FDA has this. So skin type 1 is always burns and never tans. They are never recommended to tan ever. We'll get into that later too. That's actually is required to be posted next to all tanning beds. And then, skin type 2 is burns easily, tans minimally, etc. And then this, I Googled a tanning device manual just to find out online, because I wanted to see what the recommended exposure times would be. So for example, skin type 1 is not advised ever. Skin type 2, your first week, they recommend 2 minutes. So you really shouldn't be getting up to like the 9 or 12-minute mark until week 4. And like I said, if I've ever gone, they've never batted an eye if I said I wanted to go for like 8 minutes. So technically, just keep in mind when you're doing inspections that they're supposed to be telling the customer what they can do. The operator has to give each customer a written warning statement on a form that's provided by DPH prior to their first tanning appointment, and then every 6 months after that. The operator is also supposed to sign the agreement, and it does state that there should be a witness. I don't know how often that happens, but at least the customer and the operator of the facility should be signing this. It looks like this. It's actually the same language that's required on the warning sign that's supposed to be posted, which we'll get to, I think, in the next slide. So they should be signing this before they tan for the first time and then every 6 months thereafter. So the warning sign, there has to be a warning sign, which is the same language in the previous slide, posted within 3 feet of each tanning device. They're very specific on how they want it. They want it printed in white font on a red background. All capital letter has to be at least 3/8 of an inch high. All lowercase letter has to be at least 3/16 of an inch. So I made a template of this for you because if you have an establishment that doesn't have this, sometimes it's easier to just bring these types of documents to provide to them. And I tried to make it where I measured with an actual ruler 3/8 of an inch and 3/16 of an inch. And I even changed the margins, and it wouldn't fit on an 8.5 by 11. So I ended up just Googling what font is 3/8 of an inch and what size does it have to be. I reached out to the state because I didn't want to just guess. And I said, do you guys have a template, or do you know how to measure 3/8 of an inch of a font? And they said no to both. So I think that we're in pretty good shape based off of just me Googling what 3/8 of an inch of a font is. And the required language, like I said, is the same as the DPH warning statement. And then in addition to the warning sign, there also has to be a warning that says Skin type 1 individual always burns, never tans, and should never use tanning devices. And that has to be posted with the exposure schedule. So that exposure schedule that I showed you a few slides back that had, week 1 is 2 minutes, week 4 is 5 minutes, whatever it may be, that's also technically supposed to be posted. So this is just the example I came up with. You might recognize this because, they should have these already, and this is typically what they look for, but I did recreate it, so you have it if you need it. So requirements for the tanning devices themselves, they have to be manufactured and certified to comply with the FDA. Compliance is based on the standard in effect at the time it was manufactured, and each device shall have an identification label as required by FDA. So hopefully it's somewhere visible and you don't have to go searching for it. Otherwise, they have to prove to you that it's certified to comply with the FDA. And then each tanning device shall have a timer, and the maximum timer shall not exceed the manufacturer's recommended exposure time. So I think the recommended exposure time, the maximum on the previous slide that I showed was 12 minutes. So if you go in there and you say, can you turn on the, maximum time for this bed, and it goes up to 18 minutes, then you'll have a problem. Each tanning device has to comply with the electrical code. So I don't know that the electrical inspectors are going out there annually or anything, but prior to them opening, you want to make sure that your electrical inspector is okay with it, and possibly fire and building as well. There has to be physical barriers between the customers and the lamps. So the lay down beds typically have some type of plexiglass, so you're obviously not laying directly on the lamps. And then the stand-up beds have to have some type of barrier as well. It's usually like a metal fencing kind of stuff. Burned out lamps require replacement. So again, you want to have them turn on a few of their beds and just make sure that all the lamps are working. And the interior temperature can't exceed 100 degrees. So they do take a little bit of time to warm up. So I'd make them put a few on, go do a few other things, come back. And I just use my infrared thermometer that I use during food inspections to just make sure that it's not above 100 degrees. And then again, the recommended exposure times must be available to the operator, Board of Health, and DPH. For stand-up booths, like I said, there has to be physical barriers such as handrails or floor markers to indicate where they should be standing to have the proper distance between the lamps. The booth shall be able to withstand a customer who may fall, so make sure that it's not, rocky or seems like it's kind of unsteady. The doors must open outwardly, and there has to be handrails and non-slip floors. Protective eyewear, this has to be provided by the operator. They have to maintain documentation that the eyewear meets FDA regulations, and the sanitizer has to be specifically for use on protective eyewear. So if they're just using like bleach and water or something, you want to make sure that it specifically says somewhere that it's made for eyewear. And exposure to the ultraviolet radiation from the tanning bed itself cannot be considered the sanitizing agent. And these are just kind of the common ones that I see. It's these plasticky ones. Those are the ones that they have to sanitize after. And then the bottom ones, I don't think that they're great, but I guess they're allowed. They're these disposable, they kind of turn into a cone and they go over their eyes. So those are disposable and wouldn't need to be sanitized. So records, the operator has to keep a record of each customer's risk acknowledgement certificate. I don't know why they word it like this in the regulation. They're referring to the warning statement from DPH. I think that they should keep the language consistent, but just know that warning statement that has to be signed every 6 months, they have to have a record of that. And then information about each tanning session. So the date, what their skin type was determined to be, how long they tanned for, and which device they used. And they have to keep these a minimum of 1 year. So again, the operator has to keep a record of the recommended exposure times for each tanning device. And then they have to have a copy of all applications and license information as required by this section 123.005 C1 through 6 is referring to all of the contents that are required to be on the application, which we'll get to. So I would just recommend that they keep a copy of their application on file. So injury reports, I did create one of these. It's very simple and you're welcome to utilize it. They have to prepare a written report of any tanning injury. Has to be forwarded to the local health department, DPH, and the complainant within 5 days of its occurrence or knowledge thereof. So it has to include the name of the individual, name and location of tanning facility, nature of the injury, the name and address of their healthcare provider, and any other relevant information. So sanitation, they have to have access to toilet and hand washing facilities. It has to be cleaned at least once every 24 hours. Typical, like a food establishment, soap, paper towels, and trash receptacle. And the hand wash sinks have to be between 110 and 130, which is different than the food code, different than the plumbing code. I think it's the same as the housing code, but regardless, the code specifically writes out what they want that hand wash sink to be. And customers have to have access to drinking water. And they also have to provide either paper or cloth towels. And if they are going to use cloth towels, they have to be washed and sanitized after each use. All surfaces that customers have contact with have to be disinfected. So especially the lay down beds, people typically sweat all over that plexiglass. So they have to be disinfected after each use. I have seen some tanning salons require the customer to do it. It's kind of a gray area. I don't really like that idea because you can't really confirm that the customer did it or did it properly. So really the operator should be doing that. And the disinfectant has to be EPA registered and the tanning device has to be vented. If showers are provided, the hot water has to be between 100 and 112. Floors, non-absorbent, non-slip, and slope to drain. Use of rubber mats is not allowed. And cleaned and disinfected at least once every 24 hours. Typically, in just a regular tanning salon, I don't really see showers, but in gyms that provide tanning, that's when I usually see the showers. So it's possible that they're at regular tanning salons, but mostly I've seen them in conjunction with a gym. And then just general kind of sanitation. The facility has to be maintained in good repair, safe, clean condition. And again, they put a little caveat in there about plumbing, gas, and electrical standards. So again, prior to opening an establishment, you want to make sure that all of the other inspectors, building department, fire, and electrical have been through there. And then they cannot claim or distribute materials that state tanning is safe. So inspections, the code says the Board of Health shall inspect within 30 days of licensure. I'm not sure if they meant in addition to doing a pre-op, but obviously I would recommend doing a pre-operational inspection prior to allowing them to open. And then maybe 30 days after that. And then after that, it's every 6 months. Or upon the receipt of a complaint, obviously. They also put this little caveat in, which is nice if you ever have any issues with getting access. It is specifically written into the code that you and DPH have access at all reasonable times. So the application has to be made on a form available by you. They did write into the code that the term application includes the original and renewals. So I know it's renewal season for everyone. I know everyone does renewals differently. And I actually just learned this myself while putting this together. Technically, from the way I'm interpreting this, that renewals should also be submitted on this original application, which I have a sample of. In the previous job that I worked in, we had a pretty generic renewal application for as many businesses as we could because we didn't want to have, 20 different renewal applications for everything that we permit. But looking back, we probably should have them be applying for their renewal on the application that is spelled out. And we'll get to it in the next slide. They specifically spell out what's required on that application. And then the fee and annual renewal, the fee for the annual renewal is determined by the Board of Health, as most things are. So this is what the application has to have. So it's pretty specific what they want. So Technically, it seems like they should be filling this out every year for the renewal as well. It wants the manufacturer, model number, model year, type of each ultraviolet lamp, the date of installation of each tanning device. I think that you might get a little, not pushback, but I could just hear it now. You already have that information on file. So it's up to you whether or not, if nothing's changed from year to year, if you're okay with them writing, same as last year or whatever. But technically, the way I'm reading the code is that they should be supplying this information each year. You can incorporate additional requirements, and licenses shall expire no later than 1 year, and they must be displayed in a conspicuous place. And then the renewal is no less than 30 days prior to the expiration. So we all know that you always have those people that apply for their renewal of permit the day before January 1st. So you always have this in the code to remind them that it's 30 days. Obviously, if there's any changes, they have to let you know about them, except if they are replacing lamps that are considered equivalent under FDA regulations. Again, also very common what we deal with, the license is not transferable from one person to another. Okay, so there's two kind of options. I've never had any issues with a tanning salon that were major enough that I got to this point. But it is in the code and I wanted to go over it. So there's two different kind of options. You can suspend a license, or you can deny, revoke, or refuse to renew a license. If you're going to suspend a license, that's going to be pending a hearing when you find that there's an imminent threat to health or safety of customers. So just like a food establishment, you can technically close it down without a hearing. But we'll get to it, but if you're going to deny, revoke, or refuse to renew a license, that does require a hearing. So they also specifically list out grounds for denying, revoking, or refusing to renew a license. And that's allowing a customer under 18 to use a tanning device or operate one, failing to submit the requirements pursuant to section 005, submitting incorrect information, failure to pay fees. So there's a bunch of different, options that you could deny, revoke, or refuse to renew their license. They also put, or any other additional Board of Health requirements, and they have not complied within 7 days. So if this is the case, you'll want to notify an applicant in writing of the violations for which you intend to, deny or revoke their license. They have 7 days to comply, and then the Board of Health may revoke their license after that 7-day period. I added the after holding a hearing in bold because that is not written into the code. The code has two sections, one which says the Board of Health may deny the license after the 7-day period. So to me, it sounded like you could do it after 7 days without holding a hearing. But then there was a separate paragraph, I think in the next paragraph, that said you can only do it after holding a hearing, and that the suspension is the only one that you can do prior to a hearing. So I ended up emailing the radiation program, and their attorney got back to me and said that the wording is confusing, but in summary, suspension you can do prior to a hearing, but denying, revoking, or refusing to renew a license, it has to be after a hearing. So just keep that in mind. And like I said, I've never had any major issues with tanning that we ever got to this point. But if it does, keep in mind the hearings. So if you're going to suspend the license, they shall be given an opportunity to be heard concerning the suspension. You have to hold the hearing no later than 21 days. And then the code kept mentioning having this hearing officer. The hearing officer shall determine whether the board has proved that there is an imminent threat to health or safety. And then the hearing officer shall issue a written decision. So I was confused by this, so I emailed the radiation program again, because I've never heard of a hearing officer. It's always been the Board of Health who's had kind of the authority over these hearings. And I know that building departments use hearing officers. I know our building department where I work, they have to hire an outside person to be their hearing officer. And they basically, the state got back to me and said, where you see hearing officer, they actually mean Board of Health. So don't panic that you need to go hire some special hearing officer. It's just Board of Health. I think if they were to ever rewrite the regulations, they should probably take hearing officer out and just add Board of Health. So denying, revoking, or refusing to renew a license may only happen after a hearing. And the hearing officer of Board of Health shall issue a written decision which contains a summary of what happened. So to summarize, suspension can be immediate without a hearing. However, you do have to hold a hearing within 21 days if requested. And then denying, revoking, or refusing to renew a license must hold a hearing first after 7 days of non-compliance. So here is a link to the tanning code, and then on our website, I created an application, an inspection form, which is pretty thorough. It pretty much takes everything from this PowerPoint and everything from the code, puts it in one spot for you. The sample injury form and the warning sign. And that is it. I know that was kind of quick, but like I said, the tanning code is fairly brief. And my main point today was to just kind of go over it and see if there's any questions. I can bother the radiation program again if needed.
Was one question earlier. Andrea, do you still have that question, or does anyone else have it?
Yeah, I have a question. When we did a tanning inspection, we encountered a situation where the operator or the establishment owner was having the customers disinfect the tanning devices after each use. And after looking, because we bring the code with us, so we, looked at that section, and it does not specify that the operator has to do it. So my recommendation to her was, if that's their policy, they need to have it posted in each room that the customer is responsible for cleaning and disinfecting, because otherwise the operator's not going to know or be able to ensure that the devices are disinfected. And they had the correct disinfectant, but it was just that they were putting that onus on the customer because they're short-staffed and they're doing other things like hair and nails, so they can't run up every time somebody's done their session to clean and sanitize. What are your thoughts on that?
So I've seen both. I believe I've been a customer before that had to sanitize their own place. And I do want to say it was similar where it wasn't I find that the tanning salons or the tanning establishments that are within a gym or within a hair salon, they don't get as much attention as the tanning salons that are that's what their primary job is. But I do agree with you that the code does not specify that the operator must do it. I would prefer that the operator do it every time, because you can't really confirm that the customer did it, or if the customer, did they do it properly, or did they just spray it real quick and wipe it for 3 seconds? It's a good question. I personally wouldn't. I just don't know if you could require the operator to do it unless you were to have the Board of Health vote on that.
Yeah.
But I think if you feel confident that they have good policies and procedures in place, I'm not sure that the code covers it enough for you to write it up, though.
Thank you.
Yep.
Anyone else?
I think in the chat there was a question about renewals. Do you recommend a separate renewal application just for tanning or for all permits? So, I think it depends on what it is. So for tanning, technically, yes, the way I'm interpreting it is you should have them fill out the original application every year, because in the code it says the application shall also be considered the renewal. I know at the last job I had, we had a separate renewal for trash because our trash regulations specifically required specific information. So I think, unfortunately, it really depends on every single type of establishment that we permit. The permit renewals that I've done in the past, I was able to list out majority of our establishments and then bullet point what I wanted. So from food establishments, I wanted, food protection manager, allergen, choke. For pools, I wanted CPO, bacteria testing, etc. But some like tanning and trash are just so extensive that they have to renew separately. So I think you can continue doing it on one for some businesses, but unfortunately some have to be portioned out.
I have another question, Brianna.
Yeah.
Sorry. The other thing that we noticed when we were out doing the inspection, and you touched upon the bulbs during the presentation, but just looking to see if any are burnt out. We also were looking at the brand of the bulb, because the tanning device has information on what specific bulb type is for that particular device. And
Mhm.
it'll list out like the models of those tubes. And we'll look at the tubes to make sure that it is compliant with what is on the machine as far as what is acceptable. And I mean, I have found that there, when, I don't know if maybe they stopped making certain brands, but quite often it's not the bulb that is listed on that device. So, and I don't know how big of a deal that is. I'm just assuming it has something to do with the type of radiation that bulb emits, and maybe not all bulbs are the same. So you might get higher or lower depending upon what you buy. But we ended up having the establishment owner prove to us that those particular bulb brands was sufficient for that make and model device, which meant she had to go to the person that she bought them from and get either something in writing or some sort of documentation that it's kind of like a universal, bulb that can be used in different ones. Because some of these machines are pretty old, and I don't know if maybe they just don't make those particular bulbs anymore. Do you have any advice for that? Or should we not even be looking at doing, looking at the make and model and the brand and stuff of the bulbs?
I think following the manufacturer specifications is smart. I know that the code specifically says that the bulb replacements have to be in compliance with FDA. So again, it's getting into that kind of gray area where the manufacturers says to use these types of bulbs, but the code is just saying you can use FDA bulbs. It's a good question, but I've run into that too with like really old tanning places where their bulbs have burnt out and they say they can't find replacements for them, or for that type. So that is a good point. I can ask my contact that I've emailed 3 times now in the last 2 weeks. That's a good question. I think they're a little annoyed with me because I don't think they realize that we unfortunately have to do these inspections and these questions come up. But I can ask about the bulbs and also the sanitizing. I'm gonna look at because all the sanitizing says is all surfaces with which customers have contact with shall be disinfected after each customer use, and it shall be done so with a US EPA registered disinfectant. So it's unfortunately one of those gray areas where I think at that point, as the local Board of Health, you can make the determination of what you feel comfortable with. But I can definitely ask about the bulbs. That's a good question. And then if I get an answer in time, when we send out the CEUs and the recording next week, hopefully we can include it in that email. So are there any other questions? So
See one question, Bree. If a customer provides their own eye protection, does the owner need to confirm that they are FDA approved?
well, that's another good question. I would say at this point, if it's the operator's sole responsibility, in my opinion, would be to confirm that the eye protection that they're providing is approved. I mean, you could ask them to to do that, but I think that might be a little bit of a stretch, but that's just kind of my personal opinion. I think a lot of these questions really depend on the local Board of Health and what you guys, I mean, you have kind of some room there to make determinations at the local level. I probably wouldn't, because I tend to stick to the code as much as I can just to protect myself, but you could. Or the operator could at least offer their own eye protection that they carry that they know is in compliance, and then kind of go from there. Sorry, I know that some of these answers aren't great, but
You can't quite wrap your head around your question now, feel free to email either of us afterwards, and we'll make sure if we can get an answer to the question, we'll put it in the follow-up email.
oh, there was a question that came directly to me. Some tanning establishments are utilizing computers and having their members acknowledge the warning statement, but should they have a paper version? I don't think they need to have a paper version, but you do need to be able to confirm as an inspector that the customers are signing that. So we get that sometimes with body art and rec camps. They have a lot of things on the computers now. So I would ask them to either, print out a customer's, last time that they were in with the warning statement, or I would just come around the back if they were okay with it, and I'd look at their computer and make sure that so-and-so signed off on this warning statement. And you just want to make sure that all the language is the exact same as the DPH language, because again, it's a DPH provided form. So I would be okay with it being on the computer, as long as I'm able to see it. And then another question, is it a requirement that eye protection be worn during tanning? It's required that the facility owner gives the eye protection. Once someone's in that room and they shut the door, I don't know if there's anything, I don't know if you'd ever know that they weren't using it, but they do have to at least provide it. So if there's no other questions, I don't see any. Liz, if you don't, we will follow up in the next week or so with all of the information. If you have any other specific questions, you can always email me and I can either send you the person's contact information at the radiation program, or I can email them myself. But I hope everyone has a good holiday, and we'll see you probably again. We are planning a housing code, how to write in order to correct training sometime in February. So just keep an eye out for that, because I know it's been a while since we've had any really extensive housing training. So that's going to be put on by Paul Hoffman, who we all know, and always appreciate his training. So that will be sometime hopefully in early February. So keep an eye out for that date. So thank you.